Hi, I'm Anna Denton-Jones of Refreshing Law, and in today's session I want to look at the position regarding notice pay when somebody's employment is being brought to an end by reason of incapability or ill health. You'll all know that in general terms somebody's notice entitlement is going to be determined by one of two things. We've either got the statutory minimum notice period that's set out in Section 86 of the Employment Rights Act, that idea of 1 week's notice for every year served up to a maximum of 12, or we may have a contractual notice period that perhaps goes above and beyond what that statutory minimum provides for. So in any situation we're going to have to establish which one of those two we're talking about. But then the position gets quite odd, and I must admit that I always have to sort of check this and look it up and make sure that I'm not going mad. But essentially, there are, again, two positions as regards what happens on the payment front. If somebody's notice period is that statutory minimum notice period, so it mirrors the statutory position. So let's say they've got 10 years service, so they're going to be entitled to 10 weeks notice. If that's what the contract says, or that's what we're relying on, perhaps there's no contract and we are just looking at the statutory position, then they are going to be entitled to be paid throughout that notice period. That's the case even if they've been off on the sick for a very long time, they've exhausted all statutory sick pay or company sick pay, they still are entitled to be paid for that notice period. If they are still in receipt of statutory sick pay, then obviously any amount that you're paying counts towards that entitlement. But if, and this is where it starts to get very odd, that person's entitlement to notice is actually longer, more than a week, so 1 week or more longer than the statutory minimum position, then we're in a different ballpark. And you end up in a situation where that person may be entitled to nothing. Now that sounds and feels very odd, but let me give you an example that comes from the case called Bird. And this guy had been off for 2 years. He had no entitlement to sick pay anymore because he'd exhausted it. Because of his length of service, he would have been entitled to 12 weeks notice under the statutory position, but his contract provided for 3 months contractual notice, so that's 1 week more because that's 13 weeks as opposed to 12 weeks, 1 week more. That meant the employer had no liability to pay anything for the notice period. Now that does seem counterintuitive, and the judges commented in that Bird case and said that the only reason they can think that Parliament has drafted sections 88 to 91 of the Employment Rights Act in this way is to encourage employers, almost as a bonus, to grant people longer than the statutory minimum notice periods. So it's very important in any situation where you're thinking about terminating somebody's employment that you do look at which one of those two scenarios that you're dealing with. If anyone's got any questions, please don't hesitate to contact me. My email is adenton@refreshinglawltd.co.uk. Thank you very much.